cauterise if able. Appeal in the matter of Chowdhury and First-tier Tribunal another.
Yes, Mr. Ostrowski, I think we are ready to go. Just one or two things I want to be clear about. Would you like to introduce yourself and your opposite member?
Yes, Met Physical, I appear for the Secretary of State, who is the appellant in this matter. My known friend, Mr. Malik, King's Counsel, appears for Mr. Chowdhury. The First-tier Tribunal does not appear and did not appear in the upper tribunal.
Good. Now, one or two things, if I may, first of all. The court has received, eventually, and it did take some time, physical copies of the additional authorities, which were being chased by the court on Friday, I think, last week. It took a long time and a lot of energy.
Yes, my lord, I apologise for that. My understanding was that the bundle was agreed Monday last week in soft copy, sent for copying, and then sent to this building. I've been obviously in contact with my instructing solicitor, who has a record. I forget the exact time and date that it was delivered to the post room here, but I apologise that for whatever reason it didn't make its way through to you.
You don't need me to launch into a lecture about compliance with the procedure, but it does cause real inconvenience when that is not done.
I recognise that, and I am embarrassed that.
So let that be heard where it needs to be. I'm sure it's not you, but somebody perhaps elsewhere. Right. Secondly, if I may, the court finds itself, I think, without the actual ground of appeal on which the upper tribunal granted permission. I know we've got, as it were, a reported version of that in this, at least one skeleton argument, and maybe we have indications of it elsewhere in the materials, but I'm not sure that we have the, as it were, definitive ground on which the tribunal actually granted permission.
My lord,
if we're mistaken about that, then please put us right.
Page 16 of the appeal bundle.
Yes.
Sets out.
That's what's in the Court of Appeal, and maybe it's the heading that's thrown us.
Date.
29th of December 23.
Yes.
That can't have been the document that went before the tribunal.
No, your lordships are entirely right. That document, and I confess I forget the exact chronology in which it occurred, but that document was from that document was extracted the paragraph that is in this document, beginning with the words "the upper tribunal erred." That is the entirety of what the ground of appeal was.
But there must be, that ground must be on a, as it were, on a piece of paper, which we don't have.
Your lordship must be right. I confess I cannot recall exactly what happened to that. In fact,
if you look at page 79, it might help. Out of the decision granting permission, it says documents were lodged, and that must be the application for permission to appeal, including presumably the ground, and that was granted, and there's summaries and references to it. But what is missing is the ground that the upper tribunal chairman considered and granted permission for.
That's what we need to have.
I entirely agree, and I apologise that document is not for this court. I can arrange over lunch for copies of that to be.
Well, between the parties, this ought to be possible quite swiftly,
I would certainly hope so. I'm looking through.
Mr. Malik, can you help with this?
Yes, that document is not in the bundle.
No.
But I'm sure we'll make sure that.
If you could, between you, achieve the situation in which we do have that document, we should be grateful to you. Please.
Yes. In fact, I I think I have identified the document, but I'll liaise with
All
my
right,
own friend.
well, fine, as soon as
Madam
may
Chairman.
be. Is there anything else you-
No, that's
Well, I think, subject to those things that I've mentioned, we are ready to make a start.
Your Lordship, I'm grateful for that indication. Just to confirm as well, yesterday, one additional authority and one additional piece of legislation was prepared and I believe sent in soft copy and hard copy to the court. I've been in contact through my instructing solicitor with your staff, and I understand that you now have a copy of it. It
Well,
I
what
think
is it?
sits in a separate clip, and I've handed forward additional hard copies this morning.
Right, what is it?
Yes,
Identified.
it is pages 482 to page 522, and it consists of a new index and
Yes.
then two sections of the Nationality, Immigration and Asylum Act 2002 and the authority of Shahid and the Scottish ministers in the Supreme Court.
Yes, we do have those materials.
We did have section 105, which isn't, as it happens, the only relevant section. Is there why have we got two copies of the same thing? Because I looked at the first copy.
Yes, I think it was simply an oversight that we didn't realise that 105 was already in there, but
Oh,
112 may also have been relevant.
So there's no difference between them.
Right, well, in an already very fully loaded authorities bundle, is there space enough for these materials as well?
Yes,
I'm not sure there is actually, without causing problems.
yes, I was not in receipt of a hard copy, and I didn't realise it was so overloaded. Had I known, I would of course have
But
properly.
what I'm going to do, just so that you know that I've done it, and you can remember if I don't, I'm going to put it right at the front of my core bundle, because that's got some capacity left in it. And that's where we'll find those materials, or where I will. Anyway. Good. Well, again, it rather serves to underscore what I said a little earlier,
I absolutely recognise that, and I apologise again.
which I need not repeat now. All right, yes.
In terms of the structure of my submissions, I firstly intend to orientate your lordships quite briefly in the appeal bundle and take you to the relevant documents. Then I intend to go through the key authorities that I submit support the Secretary of State's approach as to when there has been a failure to adhere to the immigration notices regulations. Then I'll apply the principles to this case. And then I'll go through the authorities that the judge and Mr. Chowdhury at first instance referred to and make clear why those can be distinguished. And finally, time permitting, I'll consider the issue raised in the respondent's notice.
Right.
In terms of the appeal bundle, I'm proceeding on the basis that your lordships have had the opportunity to consider that document, so I won't.
Yes, well, we've done that.
Yes, fine. So simply then, by way of just marking where the relevant documents are, we have at page 172 the Secretary of State's decision of November 2016, refusing.
That's the notice of decision. The decision is earlier.
Entirely correct, Mr. Lord Justice Lewis, yes. The notice of decision refusing Mr. Chowdhury's residence card and stating at page 174 that that there is no right of appeal.
It is useful to look at 170 because that is the decision. It gives the conclusion on the application, and that says the application has been refused for the reasons set out in the enclosed notice. 172 in the form letter seems to me to be what was meant to be the notice.
Indeed, so quite right. The initial decision of the First-tier Tribunal, which was under challenge in the upper tribunal, is at page 181 of the bundle. That is the decision of First-tier Tribunal Judge Mills from December 2022. And you can see that the judge confirmed that the 2016 decision was appealable, but that the appeal was out of time as it exceeded the 14 days time frame provided by the tribunal rules, and he declined to extend time on the basis of the case of Anubu, which essentially considered applications for extension of time with reference to the Denton principles. Mr. Chowdhury issued a judicial review of that decision, there being no right of appeal against a preliminary decision, and the judgment of Upper Tribunal Judge Blundell is at page 66 of the court bundle.
Yes.
That is from the 8th of December 2023, and in that judgment, at page 69, the judge sets out that the November 2016 decision fell between the case of Sala from 2016, which held that decisions such as those in place in this case, an EA residence card decision, conferred no right of appeal, and the case of Khan and the Secretary of State 2017 EWCA Civ 1755, which confirmed that Sala was wrongly decided.
Yeah.
The judge then noted the distinction between an appealable decision at paragraph 18 and a notice of decision. An appealable decision is defined in Rule 1 as a decision from which there is no right of appeal to the first-tier tribunal. By Rule 19.2, time starts to run for lodging an appeal when a prospective appellant is sent the notice of decision against which an appeal is brought. A notice of decision is not defined in the rules, so one looks to the Immigration Notices Regulations 2003, the Notices Regulations, and the judge sets out at the top of page 70 the four elements that must be included in the statement advising the person of the four things that are set out there. At page 70 onwards, from paragraph 21, the judge then considers the line of authority in consisting of 8 authorities, and at 72 at the bottom in paragraph 38, the judge concludes from that line of authorities the following 4 propositions: that there is an important distinction between an appealable decision and a notice of decision. For the purposes of bringing an appeal, time starts to run against the prospective appellant upon receipt of the notice of decision, which complies with the notice's regulations.
Is that correct? Is it receipt or is it being sent?
Forgive me, I didn't hear the
Is it receipt or being sent? Is that correct? The rules say sent, and there are provisions about what happens if you don't know the address.
Yes, your lordship is in fact correct. Yes, it is sent. The third principle the judge extracts from the authorities: for the purposes of bringing an appeal, time does not start to run against the prospective appellant where there is no notice of decision or where that notice does not comply with the notice's regulations. And there's a footnote with the words "or substantially comply" ex parte ge anthem. And then 4, a prospective appellant who received no notice of decision or a non-compliant notice of decision may nevertheless waive the Secretary of State's lack of compliance by lodging a notice of appeal against an appealable decision. The judge then granted permission to appeal at page 79, and in my submission, the key element of that document is paragraph 3, where the judge recognises that, in his words, there is some tension between that decision of Maripali and some of the other authorities I've considered in my judgment.
Do we need to look at the order, what he actually ordered, because it's an appeal against the order, and he quashed the decision of the tribunal judge and he granted a declaration?
Yes, that's at 64. And for the avoidance of doubt, the Secretary of State accepts that this notice of appeal did not, forgive me, the notice of decision did not refer to the applicant having a right of appeal, and that no fresh decision, no fresh notice was served after the case of Khan and the Secretary of State was handed down in 2017. So those are the key documents in the core bundle that I intend to take.
Can I ask a question, please?
Yes.
When the decision in Khan was handed down, was it the practice of the Secretary of State in cases such as this to send out notices, fresh notices of decision?
No, it wasn't. Those are the key documents that I intend to take you to in the core bundle. At this stage, I now intend to address you on what in my submission are the authorities, and that there are two limbs to this part of my case. The first is I'll take you to cases which deal with the situation when a public authority has failed to adhere to a procedural requirement set out in legislation more generally. And then I'll take you to cases which deal with a breach of the procedural requirements, or when a public authority or Secretary of State has failed to adhere to a procedural requirement set out in the notices regulations at issue in this case. The notices regulations are in the authorities bundle behind divider 5, forgive me, divider 4 at page 18. And as you've already seen from the content of the judgment itself, beneath regulation 5 on page 19, contents of notice, and then overleaf at the top of page 20 are the reference to right of appeal. I'll deal with 3 cases that set out the law on the non-adherence to procedural requirements in legislation generally. The starting point in my submission is the case of J. Anthem behind divider 11, which is page 55 of the authorities bundle. And a decision of the Master of the Rolls, Lord Wolf.
Yes.
This was a case where the Secretary of State appealed using a letter rather than the prescribed form, and the letter didn't have a statement of truth on, as required by Rule 13.1 of the Asylum Appeals Procedure Rules of 1993. That can be seen from next to letter E in the headnote on page 55. There was extensive discussion in this case about the distinction between mandatory and directory requirements in legislation, and Lord Wolf's position is summarised at page 59 of the authorities bundle. Next to the heading at letter E, what should be the approach to procedural regularities? In my submission, the relevant section is beginning with words on the second line. The conventional approach when there has been non-compliance with a procedural requirement laid down by a statute or regulation is to consider whether the requirement which was not complied with should be categorised as directory or mandatory. I'll let your lordships continue reading until letter G. So Lord Wolf concludes the position is more complex. The important question of what the legislature should be judged to have intended should be the consequences of non-compliance. Lord Wolf then considers Lord Hailsham's speech in the case of London and Clydesdale and Aberdeen District Council, starting at page 61. You can see next to the letter C, Lord Wolf considers examining the relevant textbooks, the relevant authorities and the leading textbooks, and then extracts a long quotation from the London and Clydesdale estate case at letter F. That then continues, and at this stage I'd invite simply your lordships to mark these passages. Particularly on page...
You want to know what you're particularly relying on?
Yes, certainly. Page 62, next to the letter D, between C and D, when Parliament lays down a statutory requirement for the exercise of legal authority, It expects its authority to be obeyed to the minutest detail, but what the courts have to decide in a particular case is the legal consequence of non-compliance on the rights of the subject viewed in light of the concrete status of facts and a continuing chain of events. It may be that what the courts are faced with is not so much a stark choice of alternatives, but a spectrum of possibilities in which one compartment or description fades gradually into another. At one end of the spectrum, there may be cases in which a fundamental obligation may have been so outrageously and flagrantly ignored or defied that the subject may safely ignore what has been done and treat it as having no legal consequences. In such case, if the defaulting authority seeks to rely on its actions, it may be that the subject is entitled to use the defect in procedure simply as a shield or defence without having to take any positive action of his own. At the other end of the spectrum, the defect in procedure may be so nugatory or trivial that the authority can safely proceed without remedial action, confident that his subject is so misguided as to rely on the fault, the courts will decline to listen to his complaint. And then it goes on saying,
Pausing there, before you get to that passage, at the bottom of page 61,
yes,
Lord Heysham actually said that the one thing that he regarded as falling into mandatory would be a failure to tell somebody of their right of appeal. And he goes on at the end of the passage after the bit you've just quoted to say that whilst there may well be gradations, a failure to tell somebody they've got a right of appeal, he regarded as mandatory. At the very least, he would have required there to have been substantial compliance.
yes. My lordship's right. I'll with your permission, address that point in the next authority that I come to, that I say does deal with that point.
So what is the proposition to which these citations
Yes.
takes us?
Yes, well, that is, in my submission, page 63, and next to the letter C, which should be sidelined, Lord Wolfe's summary of what he suggests the correct approach is. And I'll let your lordships.
So you're asking us to read 1, 2 and 3.
1, 2 and 3, and then the paragraph that follows above the word "the rules."
Right, we'll do that. Yes.
But on the facts, you apply that to the failure to use the prescribed form. And if we're applying those questions, even to a failure to tell somebody the right of appeal, it looks as if the answers might be different.
Yes, I accept what your lordship is saying. At this stage, I'm simply using this and the other two cases that I'll come to set out how the issue has been addressed in other cases. I accept that they are not directly analogous to the notices regulations. But I think it is important to at least set the framework and the groundwork for the cases that do consider the notices regulations specifically.
Right.
And just by way of conclusion, Lord Wolfe in this case, which, as Lord Justice Lewis has made clear, involved a failure to include a statement of truth, concluded at page 67, next to the letter C, that if in these appeals you concentrate on what the rules intend should be the just consequence of non-compliance with statutory requirements, I would suggest the answer to these appeals is obvious. Neither J. Antham nor Ravi Chandran have in any way been affected by the omission. It was, as far as they were concerned, a pure technicality other than to discipline the Secretary of State. There could be no reason well after the event to treat his successful applications for leave as a nullity. In my submission, as I'll attempt to make clear over the course of the following authorities, I'll suggest that Parliament did not intend that total invalidity result when there's been a breach of the requirements of the notices regulations, when either there has been substantial compliance or non-compliance has not had a material adverse effect on the recipient.
Hold on. When non-compliance or
has not had a material adverse effect on the recipient.
Where non-compliance has not had.
And I say that is part of the consequences.
You say a material.
Non-compliance has not had a material adverse effect on the recipient. I say this is part of what Lord Wolfe called the consequences question.
But how do you square that with what Lord Hitcham said?
Yes,
You're going to come to
I'm
that.
going to come on to
Yeah,
that.
okay.
Yes, and then my third submission is that Parliament did not intend total invalidity to result when there's been a breach of the requirements of notices regulations when remedying the effect of non-compliance will cause adverse procedural or other consequences. And that too is part of Lord Wolfe's consequences question.
Is that a general proposition or something which you say arises on the facts of this case?
I say it arises on facts of later authorities.
My question is whether you're saying that's something which should be considered generally, and if it were to be considered in this case, does it give rise to an issue?
Indeed, yes. The first point I make, which is in my submission part of the answer to Lord Justice Lewis's question, is that Parliament did not, on the face of the regulations, set out what the consequences should be if there is non-compliance.
When you say on the 2003 notice regulations,
Correct. And to make good that submission, I'd invite your lordships to turn to the new authority, which is behind page 489, which I think you've kept separately, of Shahid and the Scottish
but it's a different question, isn't it? Because we're not trying to invalidate the notice here or the decision to which the notice relates. You're looking at a different set of rules, the procedure rules, to see what the procedure rules
Yes.
meant.
Your lordship is right, but it seems to me that part of the answer as to why, in this case, a failure to alert a recipient to a right of appeal does not totally invalidate the notice will involve considering what the regulations say on their face. And I accept it's not a complete answer, but I say it's part of the answer. So page 489, which is the new authority, Shahid and the Scottish ministers, I say this is an example of a rule where, through necessary implication, it sets out the consequences of non-compliance. In this case, it was a rule about the segregation of prisoners from the rest of the prison population on the grounds of their own protection. The facts are helpfully set out in the head note, but we can see on the second sentence, in 2005, while he was remanded in custody, he was placed in segregation for his protection under Rule 80 of the Prisons and Young Offenders Institution, Scotland Rules 1994, the predecessor rule to Rule 94 of the 2006 rules, which was in identical form. There were then 3 occasions when orders purportedly made under Rule 94.5 for the continuation of segregation was made after the expiry of the 72-hour period ordered by the prison governor. In order, in my submission, to understand this case, I'd invite you to look at page 503, which is where Lord Reed sets out the rules themselves. So, forgive me, 502, and paragraph 7. So paragraph 7 sets out Rule 94.1 of the 2006 rules, confers a power on the governor to order the segregation of a prisoner for specified purposes, where it appears to the governor desirable for the purpose of maintaining good order or discipline, protecting the interests of any prisoner, ensuring the safety of other persons. The governor may order in writing that a prisoner shall be removed from association with other prisoners, either generally or during any period the prisoner is engaged or taking part in prescribed activity. Paragraph 8. Rule 94.5 is critical to one of the issues in this appeal. It provides any prisoner who has been removed from association generally or during any period that the prisoner is engaged in or taking part in a prescribed activity by virtue of an order made by the governor in terms of paragraph 1 shall not be subject to such removal for a period in excess of 72 hours from the time of the order, except where Scottish ministers have granted written authority on the application of the governor prior to the expiry of the said period of 72 hours. The essential point, forgive me, yes, and then I think I have to take you to paragraph 15, which is where Lord Reid summarises what he says is the critical issue, being the construction of the legislation. Considering Rule 94.5 in the first place, it plainly means that segregation by virtue of an order made under Rule 94.1 should not continue beyond the initial 72 hours from the time of the order, unless authority has been granted before the 72 hours has expired. It then cites the rule. The words "shall not be subject to such removal except" mean that what follows is a precondition to lawful segregation for a period of in excess of 72 hours from the time of the order. The words "have granted" prior to the expiry of the said period mean that in order for the condition to be satisfied, authority must have been granted before the 72-hour period expires. The essential point in my submission was that on the proper construction of the rules, a necessary precondition to the lawful segregation of a prisoner was written authority from the ministers. In the absence of that written authority, the necessary precondition of lawful segregation had not occurred, and the segregation was inevitably unlawful. The legislation spelled out the consequences of non-compliance, i.e. it meant that segregation became unlawful, and for each case where authority under Rule 94.5 was purportedly granted after the 72-hour period expired, this meant that the authority was invalid and incapable of renewal. This led Lord Reid at paragraph 20 on page 505 to say as follows, and the third line, "No amount of purposive interpretation can, however, entitle the court to disregard the plain and unambiguous terms of the legislation. The consequence of the failure to obtain authority for continued segregation prior to the expiry of the 72-hour period is ineluctably spelled out by the legislation itself. The prisoner shall not be subject to removal for a period in excess of 72 hours from the time of the order. That consequence cannot be avoided by relying, as the courts below sought to do, on such authorities as sonegi. Those authorities were concerned with situations where the legislation was silent as to the consequences of a failure to comply with the time limit, and where the intended consequences therefore had to be inferred from the underlying purpose of the legislation. The present case is fundamentally different. So, by way of analogy, I say the notices regulations could, for instance, have been phrased along the lines that a notice shall not be valid unless it includes the following matters, right of appeal, etc. This did not occur.
Yes, but that only takes one as far as sonegi, doesn't it?
Yes, it does. Yes, I simply say this as part of the, if you like, background or framework in how the courts have addressed this issue. So I now take, rather than going to sonegi, which is in the bundle, my proposal was to take you to the case of North Somerset District Council, which is behind divider 23 at page 177. And the reason I go there, it's 2010 England and Wales High Court 1505.
Where the tab number was
23. So in my submission, this gives a helpful summary of sonegi and indeed other cases. This case involved the local authority serving notices requiring payment of non-domestic rates, and the appeal was on the basis that the authority had failed to comply with the relevant regulations relating to the provisions of Regulation 5 of the Non-Domestic Rating Collection and Enforcement Local List Regulations 1989. That required that a notice shall be served as soon as practicable after the 1st of April in the relevant year. And that you can see from paragraph 2 of the authority. And the submission is that the failure to serve the notice as soon as practicable after the 1st of April in the relevant year rendered the notice invalid. In consequence, without more, that no business rates for the year are payable. The helpfulness of this authority is in the way that it summarises the previous authorities in, I say, a helpful and comprehensive manner.
This is Mr. Justice Burnett, as he then was.
Indeed, my lord, yes.
Yes.
Paragraph 25 on page 184 is the start of the summary section. It continues for a great number of paragraphs that I won't take you to, but I do invite you to consider paragraph 30, which is where the traditional dichotomy, as it was called, between mandatory and directory was considered. And I'll let your lordships read to the bottom of page 186 and the first 2 lines of 187.
I see that Mr. Holgate features in paragraph 30. How does he get a cameo appearance? Was he counsel?
He was sitting as a deputy judge in one of the
Oh,
ratings
right.
cases that were considered.
So you want us to read paragraph 30?
Paragraph 30, please. But if one stops at the very top of page 187. And then there's a summary of Lord Justice Holgate, as he then was Mr. Holgate, the factors that pointed in each direction that are set out in paragraph 30. And I next invite you to consider paragraph 38, which is page 191. Which summarises the case of Soneji. And if I could invite your lordships to read paragraph 38.
Yes.
And then the final paragraph, before I, if you like, make my submissions on what this authority says, I'd invite you to go to is paragraph 43, where Mr. Justice Burnett, as he was, sets out his summary of what the preceding authorities say. And I'd invite your lordships to consider paragraph 43 and then the quoted text that sits beneath it.
Yes.
So just pausing at that stage, I say that we've gone past the first question, which is, did Parliament intend total invalidity to result from failure to comply with the statutory requirement? We've gone past that because we know that on its face, Parliament has not said total invalidity shall result. So-
Sorry, hold on a moment. Is that correct? The first question is whether Parliament intended non-compliance to lead to the decision or here notice of decision being invalid. The clearest example of that is where the regulations say so,
Yes.
like Shahid. But there are other cases where it doesn't say so, but where the courts have clearly held that failure to comply with a provision would render a decision or action unlawful. So you can't say, can you, that the absence of express provision means that you must necessarily be in the second part?
Your lordship is right. I spoke too soon. I say more accurately, the absence of express provision is a significant marker as to what Parliament intended. But your lordship is right. You do then still have to consider whether Parliament intended total invalidity to result. And then you have to, if the answer is no to that, consider the second stage, which is set out at yes, which is whether it should nevertheless have that consequence in the circumstances of the given case.
There's lots of authorities. There's Clydesdale that we've touched on.
Yes.
And there's also one that you remind me the name of in this case, which says that the giving of information about a right of appeal is something that should be complied with. And that rather sounds as if it's within the first category, even though it's not express. And secondly, how can you even talk about substantial compliance
Yes.
if you not only don't tell him he's got a right of appeal, you tell him the opposite?
Yes. I accept the force of your lordship's questions. My response to that is, firstly, as I've said, there's no express reference to it. Secondly, what this case of North Somerset District Council helpfully says is that the discussion of mandatory and directory, effectively, the jurisprudence has moved on from that. The question is, what should the consequences be of non-compliance? And what I'll attempt to do through the discussion of the other authorities, with specific reference to the notices regulations, is make good the point that in those authorities, the courts have said that in respect of various defects, the things that are a pointer as to Parliament's intention can be seen from asking oneself the questions I asked right at the start, which is, has there been substantial compliance? Has non-compliance had a material adverse impact on the recipient? And will remedying the effect of non-compliance cause procedural or other consequent adverse procedural or other consequences?
Would it be? Is it accelerating things too much to suggest that we might get to the law as it now stands?
Yes, there's just one final section in the North Somerset case that I think I do have to refer you to, which is paragraph 46, which is a reference to the Clydesdale case and Lord Staines's decision in Senegi, and that's a reference to bona fide. Paragraph 46, Tipping J noted the delay in Charles was in good faith and in any event not long. Lord Hailsham in London and Clydesdale spoken of cases in which fundamental obligation may have been so outrageously and flagrantly ignored that an individual could safely take no notice of the purported act. In such a case, if a defaulting authority sought to rely on its action, the defect in procedure could be used as a defence without any positive action. And then towards the end of this, the concept of prejudice does not necessarily import public law concepts, although it is often a feature that requires evaluation. It is a factor that arises for consideration in countless legal environments and very often in the context of delay or failure to comply with time limits. The context in which prejudice is discussed in the authorities, dealing as they do with very different statutory schemes, imports a notion of balance. Now, I accept that that's a case which was all about delay rather than this case, which is about failure to tell the recipient of a right of appeal. But I do say that it is significant that as part of the assessment, the question of bona fides, or whether outrageous and flagrant ignorance was the root cause of the defect. So I now...
If the Secretary of State, it is her bona fides and her outrageousness, that's an issue, and the argument is going to be, well, she got it wrong, but she was doing what she thought the what the tribunal did tell her to do.
Yes.
So that's the relevance.
Indeed.
Is the lack of wrongdoing on the part of the Secretary of State is relevant, irrespective of the consequence to the individual, although the consequence to the individual is important.
Yes, that's the point I'm trying to draw out, exactly. So I now come to the authorities that deal with the notices regulations specifically. In terms of cases where there has been substantial compliance, I can deal relatively quickly with these cases because the judge himself accepted through the footnote that I took you to in the judgment that substantial compliance may be a ground for finding that total invalidity did not result. So without necessarily inviting your lordships to go to these authorities, Divider 21, the case of Majid and the Secretary of State, 2008, EWHC 2750, that one can see at paragraph 12 to 14.
Sorry, the tab again.
21.
20.
And paragraph 12, which is
Well, hold on, we
168.
need to know precisely, because here, what we're ultimately doing is construing the provisions of the procedure rules by reference to a notice, and you're saying that imports all these other things, and where the notice of decision isn't a total nullity in a judicial review context, you're saying that can also affect the construction of the regulation of the rules. So what was this case about? We need to know in each case the facts, what notice, what procedural invalidity, what consequence.
Yes, this case involved a situation where the reasons for the decision were not included in the notice. And I believe it is paragraph 12, the fourth line down. So this refers to the question of whether it was a valid notice that had been served. He submitted this is...
I still don't understand what the point is here. In this case, there's a difference between saying, can you appeal a decision and does time run because of a failure to comply with the notice of decision regulations, or whether there was an appeal brought within time and he's arguing that the decision, not the notice, but the decision should be set aside. It really is important to make sure that we've understood that. So who was challenging what legal instrument here?
This case involved a judicial review claim by Mr. Majid.
Of what? There was a decision at paragraph 2 with an accompanying notice. The notice said he'd not provided evidence of 10 years continuous lawful residence. The leave which had expired, which he had expired in March, and there's no right of appeal against the decision.
Paragraph 11 suggests that there was a challenge to a decision in a letter of the 14th of June 2007, which seems to take you back to paragraph 9.
So there's a new decision, was there on the 14th of June 2007,
Yes.
as a new claim, and it was that decision.
It was that decision that was being challenged.
So this is a JR of the substantive decision that he didn't qualify, is it?
Indeed. Yes.
So that's rather different then, yes.
Yes, it is. I accept that.
Or does it help us at all, actually?
Yes, I think I can simply leave that to one
So,
side and move
so
on.
you're not relying on that?
Not relying on the case of Majid. The case of Huang is the next case on substantial compliance, behind divider 25 at page 240. And this was a judicial review as one can see on paragraph 8.
Well, I'll look at 1 and 2 first, actually.
Yes, of course.
Just give me a moment.
Yes.
The issue before this court is now an extremely narrow one. It concerns the lawfulness of his detention at an immigration centre. If the detention is unlawful, he gets damages. Right, yeah.
Paragraph the immigration and procedural history is set out, and paragraph 8 is for present purposes the relevant feature. 10th of February 2009, notice of immigration decision involving a refusal to vary leave to enter or remain and a decision to remove was signed. This is an important document under the Immigration Notices Regulations 2003. It should have been served on the claimant, but it was not. It is crucial to what happened subsequently. There's then a discussion of the claimant reporting to immigration officers, detained in anticipation of her removal. The judicial process was invoked. The same date, unsealed copy was sent in, etc.
That was a judicial review of the actual decision.
Yes,
The decision you don't qualify for leave.
indeed. Yes, yes.
The JR of that, so we're still not into an appeal time issue for the tribunal.
No,
Yeah.
that is correct. Yes.
Right, so how does that assist us?
Well, I say the discussion at paragraph 46 and at 56 assists this court. Paragraph 46 comes under the heading of the Notice of Immigration Decision. So the immigration decision was made on the 6th of January. It was not signed until the 10th of February. It's headed, I'm reading from paragraph 45, it's headed Decision to Vary Leave. Also a second notice dated the 1st of April. And then I'll let your lordships read paragraph 46.
Yes.
So there's the reference to the wrong provision.
Indeed, yes, that was the error in that notice. And you can see at 47, the correct certification should have been under 94(1)A, the provision added by amendment. And the judge then considers various textbooks and so on, and at paragraph 56 applies those principles and the authorities to the considers the purpose of the notice regulations. I'll let you read paragraph 56.
Yes.
So I accept from that the judge draws a distinction between cases and says things may have a consequence if they fail to refer to a right of appeal, and contrast it with, on the other hand, a defect where the wrong subsection for the derivation of the power has been quoted, says that substantial compliance is far more obvious. At this stage, simply, I'm drawing the court's attention to the fact that substantial compliance has been held to be something within which the purpose of the regulations does not require invalidity to result.
Well, you have to look at paragraph 58, because what he actually decides is that I'm left in little doubt that Parliament can't have intended the failure to identify the correct statutory provisions in the notice, which would have rendered the principal, I think he means the principal decision, invalid. What he's saying is that the detention was not unlawful because there was a failure in a notice of the decision which told the immigrant about the decision, especially when the decision overall made it clear she had rights of appeal. So it's not really about time limits running, it's about the validity of the principal decision.
I consider that some assistance can be derived from what the court says about the purpose of the notices regulations, but I accept that the focus of the decision is elsewhere.
Should we not really be concentrating so far as we can on cases which have some analogy to the present case on its facts, and in particular cases where either there was silence as to the right of appeal, yes or no,
Yes.
or positively the assertion wrongly that there was no right of appeal? And it's in that realm, is it not, that the facts of this case lie?
Yes. Your Lordship, yes, I can see that is going to be the critical issue. I can move forward to what I think may be of more assistance in terms of the authorities by considering the third types of cases that I say are relevant, those being cases where there are procedural or other consequences.
I don't want to compress your argument unduly and
Yes.
or to take you out of the course you've planned for it.
Yes.
But I've only intervened in the way I have to indicate what I, for my part, would find most useful in your submissions.
Thank you. Yes, I think, and I'm grateful for that indication. I think then I can fast forward to the third type of case, because I think that is much more on point. And those are, if you recall, cases where there are adverse procedural or other consequences. That's principally the case of CM Jamaica, which is a case I place some significant reliance on behind divider 24 at page 229.
Yes.
This case again involved some procedural complexity. It involved a case where section 78 and section 92 of the Nationality, Immigration and Asylum Act of 2002 applied so as to mean at the time the notice was served that a fresh claim rather than a human rights claim was required in order to pursue an in-country right of appeal. Paragraph 3 sets out section 78 of the 2002 Act. And then at the top of page 231, we have the appeal from within the United Kingdom General. And paragraph 5 is the Court of Appeal's consideration of what the provisions mean. An individual may appeal against the Secretary of State's refusal to revoke a deportation order against him under section 84. One of the grounds upon which that individual can rely is removal in breach of his rights under the ECHR. The question then arises as to the effect of section 78, 70, and 92 upon such an appeal. Is the individual entitled to pursue the appeal from within the UK, or must he first leave the country? It was until recently believed that in order to fall within section 92, the human rights claim relied upon to defeat the deportation order must be a fresh claim. It was believed that if the human rights claim was not a fresh claim within the meaning of paragraph 353, the individual could only pursue his claim from outside the UK. That position changed on the 26th of February 2009, when the Court of Appeal allowed the appeals of PE and BA, and those two appeals, which were heard jointly, the effect of the Court of Appeal's decision was that in order to fall within section 92(4), the human rights claim did not need to be a fresh claim. The facts are somewhat detailed and are set out thereafter, and I shan't take the court through them now. But if we go to paragraph 13, we can see what the claim was about. 2006 judicial review of the decision to refuse to accept the appellant's submissions as a fresh claim. Permission was granted in 2007. Further submissions made on the appellant's behalf. They resulted in a fresh decision letter dated the 23rd of October 2008. In that decision letter, the Secretary of State went through the appellant's immigration history in very great detail, reviewed the medical evidence concerning the appellant's daughter. And then over the page at page 255, as we have decided not to reverse the decision on the earlier claim and have determined that your submissions do not amount to a fresh claim, your client has no further right of appeal within the United Kingdom. And then there's a notice, paragraph 16. The notice, and you'll see at paragraph 15 is reference to the notice of decision. But the notice contained the following passages. As your human rights claim has been treated as further representations under 353, section 92 does not apply and you are not entitled to an in-country right of appeal. And paragraph 17, under section 82, the appellant would have been entitled to appeal to the AIT. The appellant did not take that course because he believed that such an appeal must be brought from outside the UK. Instead, the appellant pursued his JR proceedings, essentially on the ground the Secretary of State ought to have treated the appellant's various submissions as a fresh claim. The purpose of these proceedings was to establish his right to make an in-country claim against the decision of October 2008.
So this wasn't about the time limits for bringing an appeal. This is about whether or not it was an in-country or an out-of-country appeal.
Yes. It bears, though, in my submission, some very significant similarities with the query that Lord Justice Lindbaum was asking, which is, this is a case where an applicant has been positively told that he has no right of appeal in country. In fact, as we'll come on to, that was wrong. He did have a right of appeal in country. So I submit the court can draw some significant assistance from this. Paragraph 21 then confirms that, as I say, somewhat tangled procedural chronology. Following the Court of Appeal's decision in BA Nigeria, the appellant amended his notice of appeal to add a new ground as his primary ground of appeal. That new ground is as follows. The Secretary of State in his decision letters had asserted the appellant's submissions did not amount to a fresh claim, and therefore the appellant had no right to an in-country right of appeal. That assertion was now shown to be incorrect.
Therefore, he was proceeding with the deportation. What's being challenged? The decision to deport? The decision it wasn't a fresh claim? One does need to know what's being attacked.
Yes, that is why I took you through the procedural chronology so far as I could.
It looks from 19 as if initially it was all on the basis that the decision not to treat it as a fresh claim, a judicial review of the decision not to treat it as a fresh claim. And now when we get into 20 or 21, it appears to metamorphosis into what are the rights of appeal.
Yes, I think that's certainly my understanding of what the case was about. It started off as a standard judicial review against a refusal to treat submissions as a fresh claim, and then
he was deported in paragraph 20. So I'm not quite sure what the appeal was all about. It helps us here anyway.
Yes. What it seems to me, paragraph 25 and 26 are probably the clearest.
21 as well, actually. But, it appears to be they are concerned now with the correctness of certain submissions. Anyway, go on. 25, you said? Yes.
Yeah. Yes. I think I'd read 21, which is that the decision not to grant an in-country right of appeal was wrong. We then have 25 and 26. Mr. Lee, for the appellant, argues the appellant has now been deported and therefore unjustly deprived of his right to pursue an in-country right of appeal. He goes on to argue such an appeal would have good prospects of success. Appellant would be substantially prejudiced if he's forced to pursue his appeal under Section 82 from Jamaica. There is then considerable consideration of the question of whether the appellant was right that an out-of-country right of appeal would prejudice the appellant. Paragraph 29 and 30 sets out the court's consideration of the issue. I found this issue immensely difficult. On the one hand, it's indeed harsh upon the appellant that he did not exercise his in-country right of appeal because his lawyers perfectly reasonably believed at the time there was no such right. The Secretary of State encouraged that belief by the decision letter and the terms of the notice of the decision. It should be noted incidentally, the information concerning the appellant's right of appeal is required to be included in the decision notice by Regulation 5.3. On the other hand, the erroneous statement of the notice in the notice of decision did not render it invalid. The appellant, if he had wished, could have asserted an in-country right of appeal. If he had done so and had contested the point, he would have succeeded, as did the appellants in BA Nigeria. So I say that paragraph is significant because that does address, indeed head-on, the first query set out by Mr. Justice Burnett, as he was in the North Somerset case, as being whether there is total invalidity, and concludes that the answer is no. You have to conduct essentially a factual assessment. There's further discussion of.
We have to remember that North Somerset was involved the construction of a statute as soon as practicable.
Yes.
The notice had to be served by the rating authority as soon as practicable. That in itself is an evaluative judgment.
Yes.
Here we're concerned with a much clearer situation where the issue is what is the consequence in terms of the running of time of a notice which either does not inform the recipient of a notice of appeal, or worse still, say there is no right of appeal. And the point is never corrected.
Yes, my lord, that's right. They are different provisions. The regulations in the North Somerset case were a timing provision that, as you say, is inherently evaluative.
And to see whether I'm keeping up with this, I had understood this case was being cited because you get to paragraph 37.
Indeed.
And this is the unscrambling point that Justice Sullivan refers to in Russia.
Yes.
And the unscrambling in that case was that, as I understand it, the person had been removed from this jurisdiction.
Yes.
He was in Jamaica, and therefore the court was looking at his exercise of a right of appeal out of country, but the unscrambling related to all that. Here, there's been no appeal at all.
My lord, that's exactly right. This case raises the unscrambling issue.
Your third heading.
Indeed, but I took you through the paragraphs that I did in paragraph 30 because I consider that paragraph 30 is significant. It is a finding by this court that the erroneous statements in the notice of decision did not render it invalid pursuant to J. Antham.
The difficulty that I have, I'm not sure, it's a bit like people making wild statements in Maripali. I'm not sure whether that is a binding thing, because he goes on at 32 and everyone seemed to assume that it was in time, and he said everybody agrees that he's going to have an appeal. So they weren't saying should there be an appeal or should there not be an appeal. The only point was in 33, where should it be an appeal from? An appeal from Jamaica or an appeal here? Should he be let back in? But you get to the end of 37, 38 and 39, and this is why I'm saying it's very important to know what was being challenged. It appears to be the deportation that was being challenged, and he was saying the deportation was lawful and that didn't have to be unscrambled, not other things.
Yes, my lord is right that it's about, and the principal reason I referred to this was in terms of the unscrambling issue, and I accept that is about the deportation order.
Exactly,
it's
so the thing that
unscrambling
didn't have to be,
the deportation.
this case is authority for the fact that if a deportation is lawful,
yes,
you don't have to, well, what is it authority for then?
Well, I say it does go further than that. This case is authority for consideration of the purpose of the notices regulations, being that a failure to adhere to what is required in the notices regulations does not automatically render the notice
Let's
totally
put it more
invalid.
narrowly than that. Does this case bind us as a matter of law to find that a notice of decision which says there's only an out-of-country appeal when there's an in-country appeal, does this case bind us to find that such a notice is not necessarily invalid, and if it involves bringing the chap back, that's a good reason for it, say, not being invalid? Or is it authority for a different point, that if a deportation is lawful, errors to do with giving the right country of appeal doesn't affect the validity of the deportation? Which is it authority for?
The latter, I accept that, which is narrow, but I do
It's authority for deportation that is lawful, not rendered unlawful, by an error as to where the appeal should be brought from,
yes,
by an error in the notice of decision.
in the notice of decision.
And the notice of decision was actually not a notice of decision about the deportation order. The notice of decision was about whether or not it was a fresh claim. Is that right?
That's my understanding of what was at issue.
So it's really an assumption or obiter dicta.
Well, well, yes. What is binding on you is the proposition that you've just set out. But I do say that it gives assistance to this court in how to interpret the notices regulations, and it gives assistance in a case where the notices regulations involve a positive assertion by the Secretary of State that there was no right of appeal in country, rather than per se, but still a positive assertion by the Secretary of State that was wrong. I think I need to go to OS Russia, which is behind divider 28 at page 277. And at first glance, this suggestion goes against, forgive me, this authority goes against the suggestion that I'm advancing, because Lord Justice Sullivan in OS Russia held that a failure to adhere to the terms of the notices regulations did mean that time started to run in this case. And again, the facts are somewhat complicated. Page 279, paragraph 4.
Well, it's better to start at 1. This is a judicial review of the notice of the decision. And this wasn't a question whether an appeal was in time, it's a judicial review of the notice.
Correct, yes. The decision of the 11th of May by the Secretary of State to exclude the UK on grounds of conduciveness and threat to national security. The letter described as the notice, confirming that there's no statutory right of appeal against the Secretary of State's decision to exclude you from the United Kingdom. However, there is an out-of-country right of appeal against the decision to cancel your indefinite leave to remain. The next relevant fact is at paragraph 11. This court gave judgment then in MK Tunisia, upholding the judgment of Collins J. Common ground in this appeal, the effect of that decision, i.e. MK Tunisia, is that a person in the position of this claimant who is abroad when given notice of the respondent's decision to cancel his indefinite leave to remain has his leave to enter the UK extended by section 3D as inserted by section 11.5 of the 2006 Act for the purpose of for the period during which he could appeal while in the UK. In that case, the period was a period of 10 days from service of the notice. During that period, he may return to the UK and make an in-country right of appeal. The statutory framework, so again, very similar, I say underlying facts, which is the law changed, granting someone a right of appeal in country when they didn't previously have that. The statutory framework is then set out from paragraph 15, referring to paragraph 16, the immigration notices regulations. And then the first instance decision of Mr. Justice Mitting, in his judgment, Mitting J having referred to MK, so this is a judgment after MK, accepted Mr. Grieve's submissions that the notice did not entirely fulfil the requirements of Regulation 5.3. It did not. It did tell the claimant he had a right of appeal. It did self-evidently notify the decision against which a right of appeal lay, correctly identified SIAC as the body to which an appeal should lie, but it was erroneous in stating that an appeal could only be brought while out of the United Kingdom. And then the critical part of Mitting J's reasoning is set out at paragraph 22 that I won't read you at this stage. There was then reference to paragraph 24, the Secretary of State relying on the statement of Lord Justice Jackson in CM Jamaica that we've just taken you to, and the passage that Lord Justice Holgate read at paragraph 37. The submissions are then set out, and the relevant part I wish to take you to is page 286.
Well, we should note at 26 that Mr. Justice Mitting has said that there was every reason not to unscramble these proceedings, so he accepted the unscrambling argument in that case.
Yes.
That's what the Court of Appeal disagreed with on the facts of that case.
Indeed, I was going to come at that point via a different part of the paragraphs, but your Lordship has identified precisely the point that I make, which is the unscrambling argument was the critical point here. And
just when we talk about unscrambling, let's be clear what we're talking about. What does that mean here?
Yes, so unscrambling in CM Jamaica.
No, in OS Russia.
Well, in OS Russia, and I'll try and get the timing as close to it as I can. MK Algeria was handed down, and I believe 11 months later, in fact, it might even have been less.
What had to be unscrambled first of all?
Well, what
Unscrambling is a word that suggests something has happened and now you're undoing it. So what are we actually talking about?
Yes, in this case, the unscrambling would have been the decisions and the litigation that transpired after service of MK Algeria.
So what happened that shouldn't have happened?
So what happened that shouldn't have happened is Mr. Justice Mitting. Well, let me start at the beginning. The notice should have said that there is an in-country right of appeal. It didn't because
what are you
MK
trying to
Algeria.
unscramble? I mean, unscrambling. You're trying. It seems to me you're trying to talk about legal decisions or states of affairs that happened.
Yes.
And have now in some way to be treated as not having happened.
Yes. The unscrambling here would have been the putting the parties back in the position that they would have been at the time MK Algeria was handed down.
Whatever date the MK decision was, giving him 10 days to come to the United Kingdom and appeal, and if he did so, letting him stay here until he appealed. So that's what we're talking about, is it, when we talk about the unscrambling, allowing him now to return to the United Kingdom for a period to make an appeal.
But
is that it?
No, that's not it.
Right.
It's not just return to the UK. It's bringing a claim based on a new ground, i.e. MK Algeria has given me a right of appeal.
But it doesn't. The understanding of the law was wrong and it's been corrected.
Yes.
And he wasn't told of the correct understanding because through no fault of anyone's in the Home Office, they didn't know that was the correct understanding.
Yes.
Presumably he was told he's got to go away and leave the United Kingdom and he can't appeal from within it. Well, in fact, he's told he can't come back to the United Kingdom.
Yes.
So the unscrambling is actually saying we will now treat the position as it should always have correctly been understood to be. And the unscrambling is to let him come in and make an appeal within 10 days.
Was he actually removed from the country?
I think, in fact, he was in the country
Because he brought JR?
because he brought judicial review.
He doesn't have to be in the country for JR. But I mean, the facts are important, Mr. Wazowski. We've really got to know. Unscrambling is just a word, you see.
No, I absolutely acknowledge that point, and I'm trying to articulate how I understand unscrambling to mean. yes, it involves returning someone to the country. That's what happened in the Jamaica case. That's one type of unscrambling, physical.
Here it's allowing him to remain in the country rather than removing himself or being removed. So he can stay here for 10 days after the MK decision and can appeal. And if he does, he can stay here till the outcome of the appeal.
Well, that's part of it. Yes, I say that's sort of physical unscrambling, i.e., are you returned to the UK from Jamaica, or are you allowed to stay in the country for 10 days pending putting an appeal in? That's one type of it. But I do say that there's another type of unscrambling, or another element of the unscrambling at issue here, and that element is legal unscrambling, if you like, paper unscrambling.
Yeah.
It is amending the grounds of appeal, amending the judicial review grounds, to put the parties back in the position that they would have been had the decision been
So
correct.
talk us through in OS Russia, judicial review of what and what ground was added?
In OS Russia, the
He's allowed to stay in appeal. And what
Yes.
else has to be unscrambled?
well, this was the point that the Court of Appeal found very little, because Mr. Justice Collins had given his decision after MK Algeria had been handed down. So in fact, and prior to him making his decision, the claimant had applied to amend his grounds of judicial review. So the Court of Appeal found very little unscrambling that was required, because if you like, the issues were already before the court and were capable of being determined by Mr. Justice Mitting at first instance. So that's why the court concluded there was firstly no, if you like, physical unscrambling, but also there was no procedural or legal unscrambling that was necessary. And that's why the court departed from the position that transpired in CM Jamaica, where in my submission there was unscrambling. Does that answer your lordship's?
No, but it doesn't matter.
Well, you're saying, Mr. Ostrowski, that that will depend on the facts. The facts in OS Russia were such that there was neither physical unscrambling, i.e. a returning of the claimant from another jurisdiction to this jurisdiction, or procedural or legal. But why would we be concerned at all with the question of unscrambling in the present case? I mean, why is the analysis? This is a neutral question. Why is the analysis here not predicated on the consequences in terms of the pursuit of an appeal of the Secretary of State? This doesn't depend on any change in the law. The Secretary of State having erroneously not really failed to bring attention to a right of appeal, but positively to have asserted that there wasn't one. Isn't that the real frame of the present case? Which does seem to me to be somewhat displaced from the context of these cases you're showing us.
Yes. I accept that there is not an authority that I can refer you to that addresses head on that issue. What I am seeking to do is to show that through these other cases that I accept are different factually and legally, there has been consideration of the underlying purpose of the notices regulations, what Parliament intended through the notices regulations, and there has been an understanding by the courts that that purpose is obviously to inform the appellant of a right of appeal, but that it includes some flexibility and some consideration that there may be circumstances where other factors apply, and those other factors I've set out. One of which I say is the question of whether there's procedural or other difficulties that would transpire.
All right, well, fine. Well, we see that point. So where do we stand now then with your argument?
So I now intend to move on to the cases that the judge at first instance relied on, and I'll attempt to distinguish those from the case that is before you today.
Right.
So by way of a summary as to where I say the submissions have got, firstly, as is I think accepted, it's not legislation where the legislation itself specifies the consequences of non-compliance. Secondly, the courts have considered the purpose of the notices regulations and have concluded in certain circumstances, I accept not directly analogous to this, but in circumstances that non-compliance does not automatically amount to the notice being invalid. And that the courts have held that Parliament did not intend total invalidity to result and time for appeal not to start to run where there's been a breach of the notices regulations in circumstances of either substantial compliance, secondly, circumstances where non-compliance has not had a material adverse impact on the recipient, and thirdly, remedying the effect of non-compliance will cause adverse procedural or other consequences.
Right.
Hold on a second. Or remedying non-compliance would have adverse procedural. That's it. Or remedying non-compliance would have adverse procedural effects.
Yes, adverse procedural or other consequences.
Or other kind. Yeah.
Now, just before I go to the authorities the judge refers to, applying those principles to this case, I say it is at least arguable that no practical purpose would result from allowing the appeal, because the appeal is doomed to fail.
Sorry, is this part of your appeal?
This is, yes.
But isn't that a different argument? Isn't that the judge below was wrong to say it was in time, but as a matter of discretion, we're not going to quash the judge's decision, because even if he'd allowed it, it was bound to fail, even assuming you're right to say that, and we know nothing about.
Yes. As I set out in my written submissions, my invitation to this court is for the court to find that the decision of the upper tribunal judge was wrong, but to remit the matter to the first-tier tribunal, for the first-tier tribunal to consider whether to admit the appeal.
Hold on, that's different though. The admission of the appeal is one thing. That turns on whether or not there should have been compliance with that particular regulation saying, advising of his right of appeal. The test of no practical purpose is something that we've seen is used in judicial review of decisions to say, well, yes, it's right, he should have decided differently, but it doesn't matter. And you're saying, you're using the JR over the first-tier tribunal to redefine the test for appeal limits, if you follow me.
I think I do follow you, my lord, and that's not what I'm doing, or not what I'm trying to do at least.
Oh, right.
I'm suggesting that no practical purpose was result because the appeal is doomed to fail. But I say the relevance of that is because that's an example of the second type of issue that Parliament did not intend invalidity to result from, i.e. non-compliance has not had a material adverse effect on the recipient. So
That's when you're challenging a decision or a notice decision in judicial review, and there's a discretion to not quash, because a decision that exists is presumed to be lawful until it's quashed. And if you decide not to quash it, because in fact there's no purpose, then that's the end of the matter. But this is different. This is, when does the time begin to run?
I'm not making a point about the remedy that a judicial review court should impose, i.e. exactly the circumstance you're suggesting, it would serve no practical purpose. What I am saying is applying the principles that I outlined to this case. This is an example of a case where at least arguably, where no practical purpose would be served, and therefore that there'd be no adverse material adverse impact.
But you've got to put it back into the first-tier tribunal. Could he have said, I'm not going to proceed any further with this case because it's hopeless? And if so, how does he do that? Are there powers to strike out?
Yes.
Or is it a question of, I interpret the time limits by reference to my judgment as to how likely it is that this appellant will succeed?
Yes, I think I can answer that by inviting you to turn to page 43 of the authorities bundle.
Yeah.
Behind divider 7.
Yeah.
Probably sensible, in fact, to start at page 42. These are the First-tier Tribunal Immigration and Asylum Chamber Rules of 2004. Part 3, Chapter 1. An appellant must start proceedings by providing a notice of appeal to the tribunal. If the person is in the United Kingdom, the notice of appeal must be received not later than 14 days after they are sent the notice of decision against which the appeal is brought. Paragraph 20. Where a notice of appeal is provided outside the time limit in Rule 19, including any extension of time, the notice of appeal must include an application for such an extension of time and the reason why the notice of appeal was not provided in time. If upon receipt of a notice of appeal, the notice appears to the tribunal to have been provided outside the time limit, but does not include an application for an extension of time, the tribunal must, unless it extends time, notify the person in writing that it proposes to treat the notice of appeal as being out of time.
Yeah.
Where the tribunal gives a notification, the person may by written notice contend the notice was given in time or should be extended. The tribunal must decide any issue under this rule as to whether a notice of appeal was given in time or whether to extend time for appealing as a preliminary issue, and may do so without a hearing. I say that what has happened here is this is something that satisfies the first paragraph of Rule 20. It appears to be a notice of appeal outside the time.
No, there was a preliminary issue and the judge said no, it's in time. That's what happened. So how can he, when deciding the simple, possibly binary question of in time or out of time, take into account the chances of whether or not the appeal will succeed? That's not something that's relevant to this decision.
I say that what the first-tier tribunal judge did, i.e. the very first instance judge did, was correct so far as it goes, which was to consider the reasons why the notice of appeal was provided late. But
No. The first question is, was it provided late? That's the first question. Then, why was it provided late? So the first question is whether it's provided late.
Yes. In my submission, the answer to that question is that the court would have to conclude that it, in order to answer whether it was late, the court would have to come to an assessment as to whether the notice was valid. In order to come to an assessment about whether the notice was valid, the court would have to take into account the factors that I've been setting out earlier.
And what those include the likelihood that the appeal would fail.
I say that that is one of the factors that the court could take into account. And so the court could conclude at a hearing that this was hopeless, this was never likely to succeed, in which case that the notice provided by the Secretary of State was not invalid, and therefore that the time was the notice was the notice of appeal, the application for permission to appeal was late and should not be extended.
Sorry, Mr. Ostrowski, I'm struggling with that. It may be my fault. How can the likelihood or unlikelihood of the appeal itself in substance favour be relevant to the validity of the appeal itself in terms of the notice of decision? What was it? Sorry, is there authority? Perhaps it's staring me in the face and I don't see it.
So I referred at the I referred in my when I started this to the three sort of limbs that I said applied, i.e., substantial compliance, no forgive me, I'll get the wording exactly right. No material adverse impact cases, and then thirdly, procedural or other consequences. The no material adverse impact cases do involve cases where the courts have concluded that if a notice was not, if the defect in the notice was not something that caused a material adverse impact, then that meant that the notice was not invalid.
Yeah, well, this is the context here is the question of when time began to run, isn't it? Isn't that the real focal point of the case?
Yes, and if the notice is held to be valid, then time starts to run from.
The first-tier tribunal isn't actually deciding whether the notice of decision is valid. He's asking whether a notice of decision which met the requirements substantially, assume that, of the regulations were met. Here, they weren't met. I mean, it's hard to say there wasn't substantial incompliance with one of the principal provisions of the regulations when he was told not only that he didn't, what his appeal rights were, he was told, however understandably, that he didn't have any rights. So he's not been told that.
Yes.
And the question then is, if you have a notice which doesn't comply with that requirement, did Parliament, when it approved the procedural rules, intend the FTT to decide whether it was in time or out of time by asking whether or not the appeal will ultimately succeed, or be likely to succeed, or might succeed? I say yes.
I say yes. I accept that that is a potentially heavy burden on the first-tier tribunal, but that is consistent with the fact that the tribunal rules addressing late notice of appeals were amended to allow first-tier tribunal judges to consider the issue of timeliness at a hearing. Previously, they weren't, and I say that's a significant factor behind the line of authorities that I'll take you to that the judge goes through, where the tribunal found that there was no way that they could conclude.
And does the FTT also have to ask, I know Khan was decided in 2017, when did you first learn of the right to appeal? And if it's more than 14 days after he first learned of it, as opposed to when a notice was sent,
Yes.
does he have an ability to say, well, I'm not going to treat this appeal notice as being in time because I think you should have done it too?
I say those are the factors that
You can
the
look at
first-tier
those.
tribunal judge should consider. I don't shy away from that, and I accept that as I said a few minutes ago, does put a heavy burden on a first-tier tribunal judge. But that is the correct question to ask, and in my submission it is consistent with the interpretation of the regulations that I've set out so far.
Could I ask, please, if we go back to the 2014 rules, it seems to turn on Rule 19.2. And the issue seems to be whether the document in question, the notice of decision, answers to the description given in the regulations, read with the other provisions which deal with the contents of such a notice. Let's imagine that we had a situation, not this case, where judicial review proceedings have been started challenging the notice of decision. As I understand it's your case, that in deciding whether or not the notice of decision is compliant with 19.2 and the other provisions, you read in the tests from Jane Thean and the other following authorities, substantial compliance, or your second and third headings as well. Have I understood? If there were to be a judicial review.
Yes, the reason I'm hesitating is 19.2 is about the Mr. Chowdhury's notice of appeal against the decision of the
Yes,
Secretary
but
of State.
all these regulations are referring to a notice of decision. That's what
Yes.
I'm asking.
Yes.
So if there were we've seen from some of the cases that there can be a challenge by way of JR
Yes.
to the notice of decision. Alternatively, the Secretary of State might have served a vote, etc. But when, on the other hand, picking up my Lord's question, we're looking at the tribunal, the FTT,
Yes.
applying this regulation. Is it your submission that it has to ask itself whether it has in front of it a notice of decision answering to that statutory language?
Yes.
And you say it's for that reason that the Jane Thean criteria are equally relevant in that context.
Yes, I do. Yes.
So you're saying you can read things like purpose and so on, not as part of the discretion of the Judicial Review Court when considering the judicial review of a notice. You can say the same sorts of states of affairs with the same sorts of labels are built into the question of substantial compliance.
Yes, I do. That is what I say the task of the first-tier tribunal judge.
The task involves ascertaining whether there is a valid notice of decision.
The task will involve ascertaining whether there's a valid notice of decision. In order to assess whether the notice is valid, the first-tier tribunal judge will have to consider the three factors that I set out, i.e. substantial compliance, whether there's been a material adverse effect, and procedural or other consequences.
There has been substantial compliance in reality, hasn't there? I mean, there's obviously substantial non-compliance in terms of he was told the opposite of what he should have been told. There's no unscrambling because all he's got to do is put his notice of appeal. There's no need to unscramble anything. That which should have been able to happen in 2016 can happen now. The real issue, I think, from what you say, is whether the fact that a court might have said, if it was dealing with judicial review, well, I'm not going to quash it because he would have lost anyway, like Marapalli, who didn't actually meet the requirements, and everybody accepted that, is whether the fact that he might lose his appeal is something that's relevant to substantial compliance. That seems to be the nub of it now.
Indeed, I accept that the substantial compliance point is not a runner for the reasons you outline. I disagree with you on the question of adverse procedural or other consequences for two reasons. Well, for this reason, yes, it doesn't involve physical unscrambling, but it does involve adverse procedural or other consequences in the wider sense. It involves unscrambling of what happened in this case and the...
No, it doesn't. They're not unscrambling anything. I mean, all that happened was a decision was taken on the 30th of November 2016. He was notified that on the 30th of December 2016, but he wasn't told about the right of appeal. So all that happens now is that he brings his right of appeal. You're not unscrambling anything, are you?
Well, I say that the other litigation that was involved is relevant. I accept that
It's
only.
not going to be unscrambled. They raised other issues and they've been determined, but they have no bearing on the issues in this case.
I can understand my lordship's points. I accept it's not my strongest argument. My strongest argument is the final one, which is no material adverse effect, because it is at least arguable it was doomed to fail.
But how do we know until we have the appeal? And he turns up with his uncle and says, well, yes, actually, he did live with me. He had the upstairs back bedroom. And actually, I did cook every meal and I did give him money. And he couldn't, notwithstanding what he said to the immigration authorities, have managed without it. I mean, that might be true. We don't know, do we?
Yeah, I mean, it is exactly those type of factual evidential questions that the tribunal could determine at a hearing. That is consistent with the changing of the rules to allow first-tier tribunal judges to have a hearing. Now, of course, it would make no sense to have an entire appeal at that preliminary stage, but in my submission, that's not a hurdle. The courts are used to what is effectively a sort of summary judgment type test, which is, well, you know, is there enough on the papers taking the applicant's case at its highest, hearing the submissions to say, yes, you know, this is someone who was reliant on his uncle, dependent on his uncle in the way that's required under the regulations.
But to see if I'm keeping up with you, what is, as I've understood from your skeleton, you're arguing is that an FTT judge faced with a situation like this has to ask himself, under 19.2, do we have here a notice of decision which is compliant with the legislation? And that involves, you say, having regard to JMCM criteria.
Yes.
But presumably that's only correct insofar as someone raises those points. For example, in this case, did the Secretary of State say and ask the judge to determine that this appeal, if it were to go ahead, would be hopeless? It doesn't feature in the FTT's decision.
No, the first-tier tribunal
So
judge.
how can it be raised in this court?
I say it follows from the fact that the first-tier tribunal judge did consider the point about timing.
But he said there wasn't a good explanation for failure to comply with the time limits.
Yes.
That's a different issue.
Well, I say it must be related that if the first-tier tribunal judge can determine at a hearing whether a notice of appeal was given in time, that must mean that the tribunal judge can consider exactly the points that we're discussing
You
here.
have to give an explanation for delay, as I think my lord has observed already, if you're out of time. Here we're at the prior question, have we got a notice which complies with the legislation? So I'm trying to understand your analysis,
Yes.
building in the JNCM criteria, but even if one goes that far,
Yes.
presumably at the point when you say that ought to be determined, a party should raise the issue. The fact, for example, that the appeal is hopeless,
Yes.
and ask the judge to reach a view on that and then weigh that in his evaluation.
That is something that would have to happen, and in my submission, it would not require input from the Secretary of State to do that, because the judge would know from the face of the documents, the timings, would know the date that the notice of decision.
That's not the point. The question is, what he doesn't know is what evidence he's going to produce about the uncle and the dependency. That's the problem. And the difficulty that I've got here is that we have substantial compliance and we talk about no purpose. And I think we have moved into another world when we talk about no purpose because the appeal would not succeed. That is not the sort of factors that's relevant to substantial compliance about telling somebody about the right of appeal. It is more relevant, and that's why I kept asking, what are these cases all about? To a judicial review type of case where the answer is yes, the first-tier tribunal was absolutely right. It was out of time, but it doesn't make any difference because we know that he's not going to succeed. For example, as in Marapali, where he brought judicial review instead of an appeal. So I wonder whether the philosophical problem that you've got is that you're using the factors that are relevant to substantial compliance for the notice as broad enough to include the kinds of considerations that might persuade a judicial review court if it was dealing with the judicial review of the notice, not to intervene.
Um,
Do I put that clearly?
You have, my lord, and I say that is what I'm doing. I say that the authorities do enable this court to consider the types of issues that were considered in judicial review decisions and import them into making the type of assessments about the validity of notices that is before this court and would be before a first-tier tribunal judge.
And the other interesting question then is if it's not dependency, it's he knew all along that he had a right of appeal. He'd read Khan, his solicitor had told him about it, but he decided to wait. Is that something that the FTT can? Judges don't like the sound of that. It looks as if people are deliberately waiting, but the answer may be Secretary of State can send another notice. That's all she's got to do. Wasn't her fault she got it wrong first time, but once she knows it's wrong, she sends another one.
I think that could be, in theory, an approach that the first-tier tribunal judges go down. I wouldn't, because it is vulnerable to exactly the reverse argument, which is, well, why didn't the Secretary of State send a fresh notice in 2017? I say what's going to be more relevant if this case was back in front of a first-tier tribunal judge assessing the validity of the notice would be whether it would have made any difference at all.
Because the appeal would fail.
Yes.
Yeah.
It is an odd concept though, isn't it, in asking oneself the question is, has there been substantial compliance, which is the fundamental requirement here, with the obligation to serve a notice of decision, to actually second guess the potential outcome of an appeal when all you're dealing with is an initial procedural requirement which sets the running of time.
Yes.
Well, that was really much more eloquently put than I did. The thrust of the question I asked you originally.
Yes. I can accept that. I don't think I can improve on my submission earlier that it would put a burden on a first-tier tribunal judge, and I can see why your lordship described it as unusual. I say it's consistent though with the authorities, and of course a first-tier tribunal judge would be well aware of the fact that he or she is not determining the appeal for good, that essentially this is a threshold or gateway assessment, and is going to structure their judgment accordingly. It's not going to embark on a, if you like, full merits assessment of the case. It's going to consider whether it is hopeless, the appeal. And that is something that courts do in...
Well, they certainly do if they're faced with an application to extend time. But of course that's the next stage if it's out of time.
Yes.
What, for my part, strikes me as unusual is the notion that in dealing with the first prior
Yes.
issue... okay.
Yes, I hope I've answered at least
Yes,
the
indeed.
submissions that
Thank
I
you.
make on that. I'm conscious of the time. I intend in that certainly until lunch I'll go no further than 1 o'clock to go through the authorities that the judge refers to.
You mean you're going to complete your argument by 1 o'clock?
Indeed, yes. Yes, I'm going to complete my argument. I've spoken with Mr. Malik, complete my argument by 1 o'clock.
Okay.
So the judge considers, as you'll recall, 8 cases in his judgment. But the headline submissions in response to them all are that these involve cases where the court could not conclude that there would be no material adverse impact on the recipient, or they couldn't conclude that there had been substantial compliance, or they couldn't conclude that remedying the effect, remedying the defect.
Sorry, it goes as again. There were cases where the court could not conclude, one, that there could be no material adverse effect.
Effect on the recipient, or the court could not conclude that there had been substantial compliance, or the court could not conclude that remedying the effect would cause substantial procedural or other consequences. Or separately, they involved a concession by the Secretary of State.
And none of them bind us anyway, do they?
No. Forgive me. 6 of them are upper tribunal cases, but OS Russia.
West Russia is the Court of Appeal. Yes.
Indeed. And there's also the case of Khan, that's a Court of Appeal case that I'll take you to. That case, not the Khan that followed Shamsi Saleh, another.
No, but that's just one paragraph which is dealt with in Maripli, and that records the common position of the parties and doesn't decide it either, I think.
Precisely my point. It involved a concession by the Secretary of State, and I say that concession was wrongly given. Yeah. So I can deal with that. I've dealt with OS Russia. Therefore, there are 6 cases left. They don't bind this court, but I think it is appropriate, nevertheless, to go through them relatively briefly,
Right.
and then I can sit down.
Thank you.
The first case is behind divider 13, the case of Mohammed Omar. This involved a grant of exceptional leave to remain for 6 months for the applicant, rather than granting asylum. But the grant of exceptional leave stated that he had a grant of appeal against, stated that he did not have a grant of appeal against the asylum decision. And that was plainly wrong. The facts, briefly, are we see paragraph 1 appealing against the determination of the adjudicator in July 2001, refusing to vary leave to enter. There's then a claim for asylum refused in July 2001 on paragraph 2. The notice contains a notice that the appellant had a right to appeal. Paragraph 3, confusingly, a different section of the Home Office granted exceptional leave to remain for 6 months, but didn't notify the appellant. Paragraph 4, the appellant, unaware of that decision, appealed against the refusal to vary leave, came before the adjudicator in 2002. Paragraph 6, March 2002, appellant granted leave to remain. Grant only came today, and you can see the terms of that grant. You may refuse. You may appeal against the decision to refuse you asylum on grounds to leave the United Kingdom after the time would be contrary to the UK's obligations under the convention. And then paragraph 7 is probably the critical part. This, if it was intended to be a notice, it's inadequate. It not only fails to indicate the statutory basis of any right of appeal, but misstates the right of appeal, because if it intended to indicate a right of appeal under section 16.3, the right is not an appeal against the decision to refuse you asylum. It's not a valid grant of leave, according to the appellant. They disagree. The grant of leave is valid. But because of the deficiencies in regard to the notice regulations, it must be right to say the Secretary of State would not be entitled to take any point on, for example, the lateness of any appeal. So the short point there is that because the right of appeal was not specified, the court could not conclude that it that there had been substantial compliance, or that there wouldn't have been a material adverse impact on the recipient. So quite straightforwardly, the reason for that decision in my submission. I'm conscious that it may not assist the court to go through these in detail, but perhaps at least for the court's note, the next authority referred to by the judge was at divider 16, the case of ZA Ethiopia.
Just before we put this. I'll then go through them now.
Yes, there are various ways of doing this.
Indeed.
I just wonder whether indicating the paragraphs that you particularly rely on
Yes, perhaps that's easiest, yes.
And you could do that now, or you could do it if you wish after either over the adjournment or very shortly after the conclusion of the hearing. I think actually for the sake of good order, it would be best to know exactly before Mr. Malik has to make his submissions.
Yes.
Which passages you're particularly relying on.
Yes.
So you can trust us, of course, to read the passages in their context.
Yes.
Can you do that for us?
I certainly can do that, and I
Why
can
not do
entirely,
that? It
yes.
will save time without, I assure you, any detriment to your argument.
No, and I'm conscious that it's not an effective use of the court's time for me to go through in detail.
Okay, well, we'll do it that way then. if that's
Yes,
all right.
so ZA Ethiopia, that's divider 16.
Yeah.
And it's paragraphs 23 to 27 at page 103 to 104. The next authority is the case of OI, Notice of Decision Time Calculations, Nigeria, 2006.
Sorry.
Tab 18.
Sorry.
Yes, I didn't say that. Tab 18, OI Notice of Decision Nigeria from 2006. And the relevant parts of that are paragraphs 10 through to 14. And 10 through to 15 on page 136 to 137. Then divider 19, which is FO and others, Service of the Notice of Decision, Nigeria 2007, UKAIT 0093. I just paused to interpose at this point. This case makes specific reference to the old version of the rules, where the first-tier tribunal had to determine what's now Rule 20 without a hearing. So the relevant passages there are paragraph 1, paragraph 5 to 8, paragraph 11 to 12, and paragraph 14 to 15.
Yes.
The next case is Abiat behind divider 26. I say this is simply, it's referred to by the judge, but not helpful, but one can see paragraph 31 is the reference the judge relies on.
Sorry, the paragraph again.
31 on page 266. The next case the judge refers to is that of Khan, which is divider 31. This is the upper tribunal case of Khan, 2015 UK UT 00353, behind page 312. And the relevant passages here are paragraph 8 to 12, paragraph 19, paragraph 23, paragraph 20 to 21, and paragraph 23 to 24.
Is this the one that went on to the?
Yes, I was just going to come to that. Yes, this is the one that then comes on to the Court of Appeal, which I'll go to next. That's divider 35 at page 383. And I will just interpose at this point that the critical point I've discussed with Lord Justice Lewis is the concession made on the Secretary of State at paragraph 24. I'll simply read that out. That's at page 390. I should record that it was common ground before us that if the claimant had now to pursue an appeal to the first-tier tribunal, there'd be no distinct point about such an appeal being out of time. That is because if he is right, he has never received a valid decision notice, see paragraph 22 above, and accordingly time has never started to run against him. So I think we do then need to turn to paragraph 22, which is at page 389. The OS Russia point, and I've taken your lordships to OS Russia, is a little less straightforward. It was common ground before us that if the claimant is right in his basic case that he enjoyed a statutory right of appeal, the decision notice was invalid because it said that he had no such right. that is what, so far as relevant, the OS Russia case decides. I hope you've heard my submissions on that. I say that the OS Russia case does not, in fact, decide in as blunt and clear terms as that every case of defective notices means that they are invalid and times does not start to run. The next case in the chronology the judge referred to is Divider 32. I say not relevant, but the judge refers to paragraph 12, simply for your note.
That's the case of Singh, yes?
BJ, yes, Singh explained,
I'm sorry,
2016
BJ
UK UT. Correct, yeah, Divider 32. And it's really what's at paragraphs 11 to 13 on page 330. And then the final authority is that of OS Russia. That's Divider 28. And I've taken your lordships to that, and you've heard my submissions on that.
Yeah, I'm sorry, I was inadvertent when you were referring to
28.
Yes, I was inadvertent when you were referring to Khan and the Court of Appeal just now, and it was the paragraph reference that you took us to question the summation of what had been decided in
It's essentially paragraph 22 and 24 at page 389 and 390.
Yeah, 22 is the paragraph I missed.
Yes, 22 and 24.
Thank you. Right.
Well, I think that has helpfully speeded up the submissions I was going to make on those authorities. You have my headline points and now the paragraph references. Unless I can assist you further, that means I'm finishing slightly ahead of my.
You're not going to argue that Marapelli is binding on us to say that you're right.
Yes.
I thought
Forgive me,
that was the ground of appeal.
No,
But
no.
we've never had the ground of appeal, but that's what you say it is.
Yes. Sorry. Yes,
You don't
I
have
realised
to.
through the.
I'm quite happy to bury Marapelli.
No, through the discussion that I'd missed the part of my submissions where I address you on that. If you just let me find the correct place.
Do you want just to gather your thoughts?
Thank you. Yes. Yes, thank you. Marapelli, which is Divider 36. Page 393. And this too involved a somewhat convoluted factual scenario. An appeal against the decision of the upper tribunal, which in turn dismissed an appeal from the first-tier tribunal that had dismissed an appeal by Mr. Marapelli against the decision of 2019, refusing the application for indefinite leave to remain on the basis of 10 years continuous lawful residence. A 2017 application refused in March 2017. The notice did not inform him of a right of appeal. The appellant contends that his application has not been determined in Section 3C of the Immigration Act.
2A is important, not C. Yes, sorry.
Yes, your lordship's entirely right. 3C2A extended his existing leave to remain until a notice was served. And he contends that he had therefore completed 10 years continuous lawful residence and was entitled to indefinite leave to remain under paragraph 2 of the immigration rules, and that the Secretary of State was therefore wrong to refuse his application for indefinite leave to remain. The legal framework is then set out.
The key thing to note is that the decision which failed to include a fully proper notice was the 25th of January 17 decision, but there was no appeal. There'd actually been an unsuccessful judicial review, but that wasn't what was being sought to appeal. This was a different challenge as to a later decision on different grounds of the 6th of June 2019, and it wasn't said that there was any defect in that decision. What it was said was the earlier decision should have been treated as never having been made because there was an error in the accompanying notice of decision.
Yes.
That's
Yes.
what the case was about.
Yes, my lord. Yes, I accept that, and I can see why you draw the court's attention to those points. The factual background is then set out at from paragraph 10, page 396. There's then reference to the application for Tier 5 leave in January 2017. And that notice, paragraph 16, accompanied by a statement of reasons, not informing the appellant he had a right to appeal against the decision, but erroneously telling him that he had a right to seek an administrative review. That then played out.
Well, he sought judicial review of that because he was told he couldn't appeal, and the permission was refused because it was obvious that he couldn't succeed on any challenge to the underlying substantive decision, because he clearly didn't meet the requirements for being a charity worker. He was neither a worker nor was he a worker for a charity.
Yes.
Yeah.
Yeah. I think I can go skip ahead of the detailed procedural chronology that then applies to paragraph 30, where the appeal begins. The permission to appeal against the decision of the upper tribunal granted by Lady Justice Lane, 4 grounds. Finding that the appellant, the upper tribunal had erred in finding the appellant had waived his right to appeal, misunderstanding the appellant's case, failing to understand the importance of the right to appeal as applicable at the material time, making an irrational finding that removing would not be ordinate, and failing to give adequate reasons. The Secretary of State accepted that ground 1 of the appeal was well founded initially, but then at paragraph 33, a respondent's notice was served and relying on 2 initial grounds. Firstly, that it was an abusive process for the appellant to raise the issue that the respondent had failed to inform him of the right to appeal, as he should have raised that issue as part of the judicial review. And secondly, the upper tribunal would have been bound to dismiss the appeal in any event, as the appellant did not qualify for Tier 5 temporary worker status, and any appeal would have failed, and any leave he had would have come to an end in 2017. Thus, the appellant could not have qualified for indefinite leave to remain in 2019 on the basis of continuous lawful residence. It's fair to say, in summary, it was that second issue as encapsulated by Lord Justice Lewis that was the focus of the Court of Appeal's decision.
No, we never decided that, I thought.
Didn't
we say we didn't have to get to that?
Yes, I
Paragraph 56.
yes, I didn't articulate that well. The issue about the fact that the appellant could not succeed under the rules was the critical issue for the Court of Appeal. In the course of this discussion, there are relevant passages relating to the notices regulations. Paragraph 44, under the heading of general principles. One of the functions of the notice, therefore, is to give the applicant information about the right to appeal against a particular decision. The fact that the notice does not do so may have consequences, particularly where the person wishes to appeal against the decision. By way of example, a person wishing to appeal against a decision has to provide the tribunal with notice of appeal within 14 days, see Rule 19. Failure to notify the person may be a good reason for extending the time for appealing under Rule 4.3 of the rules. Further, if a notice is quashed in a claim for judicial review, then there will be no notice of a decision in existence, and the respondent may have to send a fresh notice of the decision, and the time for appealing against the decision may begin from that date. If the notice is not quashed, however, it will continue to exist and may continue to have legal effect. The fact that a notice is deficient and does not give all the relevant information does not, therefore, mean that the notice is necessarily and for all time legally ineffective, and that is consistent with the decision in E1 OS Russia. The next relevant part that I invite the court to read is paragraph 47. If I can invite the court to read that paragraph.
Yes.
And then the last two paragraphs I'll take the court to. Paragraph 51 at the bottom of 50 at the bottom of page 403, which I can perhaps paraphrase simply by summarising the point I've already made to your lordships about the limitations of Khan being simply that it was proceeded on concession from the Secretary of State. And then at paragraph 51, if I can invite the court simply to read paragraph 51 and 54 on page 404.
You went to 54.
No, 51 and
Oh,
54.
and 54.
Yes.
52 is quite interesting. And the problem is, obviously what I said. I wish now I hadn't said it the way I said it. But the difficulty is, this was not about the time running for the challenge to the January 2017 decision that failed to give notice. This was a claim that a later decision should proceed on the basis that the earlier decision, substantive decision, was invalid. Sorry, it had never been determined because of the failure around in the notice. And I was saying, no, it's not possible to do that. Having had a discussion of general principle which is neither full nor helpful, the key binding nature of this decision is that you can't, when challenging a later decision, automatically assume that an earlier decision has never been taken because an accompanying notice had a defect. That's
Yes.
what it decides, isn't it?
Yes, I say that encapsulation of the principle is it is something that is still consistent with the grounds of appeal I advanced today.
It's not inconsistent, you just wasn't dealing with it.
I accept it doesn't deal head on with the principle before the court today. But I say, firstly, at the very least, it's not inconsistent.
Yes.
And secondly, I say it does provide some support for the overarching or underlying point that I make today, which is that in assessing the validity or otherwise of a notice that is defective under the notices regulations, that the court can consider the question of whether there is a material adverse impact on the recipient. And what was decisive in Marapali was that there was no material adverse impact because his application was bound to fail.
Yeah, but we can't get away with that. All of that is correct, but it simply wasn't dealing with when did time begin to run for the January 2017 decision.
I accept that it doesn't address that head on, and I acknowledge that that's somewhat undermines the specific ground of appeal that I've advanced before this court. But my intention and my submission is that it's encapsulated in the grounds of appeal before this court as I've developed them.
Yeah.
Right. So you'd invited us to 54, and then
Yes, I think really my submissions had probably been preempted with the discussion I've just had with Lord Justice Lewis.
yes,
I won't repeat them unless you wish me to.
no, there's no need to do that. That's fine.
Those are my submissions on Maripol Inn, and thank you for reminding me that I've forgotten to address you in that case.
You want to pause just to make sure there's nothing else you need to.
Thank you. I will just check that. Yes. Yes. If I just turn on that. Mr. Malik has helpfully reminded me about the respondent's notice that I do intend to deal you with just over the course of 5 minutes, and I can obviously elaborate in reply.
Right.
The alternative that he shouldn't have said it was no good reason for extending time. Is that it?
Exactly, yes.
Yeah.
The respondent's notice is at page 47 of the core bundle.
37, I think.
I think there was an amended respondent's notice because it's substantively identical, but
Okay, I'm sorry, I hadn't picked that up.
You mean 47?
forgive me, 46. Sorry, 46. Even if the First-tier Tribunal was right in holding the respondent's appeal to it was out of time, as contended by the Secretary of State, it had erred in law in failing to extend time. Given the Secretary of State had not issued a notice in accordance with the notice regulations, the delay in bringing the appeal was not serious or substantial. There's good reason for delay, namely the respondent's failure to comply with the notice regulations. In any event, on all the circumstances, time should have been extended. I have covered, I think, the substantive response to this respondent's notice in the submissions I made about how a first-tier tribunal should deal with a situation like this. The First-tier Tribunal has the right to have a hearing under the rules in considering the 3 Denton-Mitchell principles, the seriousness or significance of the breach, the reason why the failure or default occurred, and all the circumstances of the case. The First-tier Tribunal judge would be able to assess, in particular, my submission, all the circumstances of the case.
You say there's a hearing. It was on the paper that there's no oral hearing with submissions or evidence, was there?
No.
He had the notice of appeal, didn't he, and the decision and the notice of decision.
Yes, exactly right. Yes.
So he didn't hold a hearing, did he?
No, he didn't. No, I don't think I said that. I said that the rules permit a hearing to occur, and that is what I say should occur. And the critical issue is going to be all the circumstances of the case, and that is going to include whether, in any event, he could succeed, given the absence of any evidence of dependency on his uncle, and the positive evidence that was before the Secretary of State from previous applications he had made for leave to remain as a student, that he was independent and not dependent. And that would also include, in my submission, why the applicant had delayed bringing an appeal for 6 years after Khan had been handed down in 2017. In my submission, that approach would be consistent with the purpose of the First-tier Tribunal rules, which at Rule 2 is to deal with cases justly and fairly, and would be consistent with the focus on each individual case being assessed on its merits and individually. and in my submission, the notion that every single case where the original decision was made after Sala, but before Khan, should result in a right of appeal because time should not be extended, it is wrong. There should be an individual assessment, and when that is done, in my submission, it would result in the finding that the application to appeal was out of time.
Right, and you're saying that wouldn't necessarily follow in every case,
Yes,
and it would depend on what?
it would depend on, well, obviously it would depend on the facts in every case, but in a case like this, the critical issue would seem to me to be, in my submission, whether the application was doomed to fail. And so that would involve the type of discussion, the issues that were discussed earlier, i.e. Why did the appellants, Mr. Chowdhury, say that he was independent when he applied for student leave?
Right. So we're back to that.
Indeed.
Right, thank you.
It's 1 o'clock, and unless I can assist you further, those are submissions on behalf of the event.
Ask the question.
No, just you won't forget actually identifying the document with the ground of appeal. Yeah.
Yes, thank you.
We would like that, please. Thank you very much, Mr. Strong. So, Mr. Malik, we'll start with your submissions then at 2 o'clock.
Yes.